Well, nighttime criminal law peeps, this is our makeup from election night last week. Kind of a summary of justifiable use of deadly force. And Chapter 6, the second part of Chapter 6, not the police aspect, but the individual aspect, starting on page 142. Right here in those bullet points that we'll get to in just a second in review. And what I need to remind you about is what a civilized society's response is to the use of force. And let's look at it from the two individuals, two competent adults, who neither is in charge of the other, neither is the boss of the other, neither is a superior to the other, neither is related to the other. Our use of force against another person in our community has no place from either party. Both people have that same equal right to continue in a direction that they travel, the direction that they choose to take without interference. That's the idea of free will, choice, freedom. The only way to stop that one person is to force them or threaten them. And so in a civilized society in the 21st century, we reject the idea that someone can use force against us. Might is not right just because you're larger, just because you're more physically capable, or just because you're more dangerous, just because you're a bully, just because you have armed yourself. We prize the intellect. We prize our ability to communicate over the ability to force somebody, to use power or violence or brutality against somebody. We strongly prize the ability to talk things out over the use of force, but yet the sword still has a place in the 21st century. We can't trust every person, yet we need to offer some trust to everybody if we want the trust reciprocated, if we want the right to be free from being forced, if we want to have freedom. We do not want to be controlled by another person, and we can't control another person. It is mutual. It is part of our communal existence. So that's the one-on-one relationship with another person. So what is our relationship then to those two people as a community? And that relationship turns on how we define what one or the other did with that use of force. Is it offensive or defensive? We are going to permit defensive violence against another adult human being, and not offensive violence. So and if it's offensive, we're going to call it criminal. And if it's defensive, it is justifiable. Largely the difference between justifiable and criminal turns on the notion of temporal proximity. How much time has elapsed between the necessity for that use of force to protect yourself and the actual protection or threat of protection? The longer the thought process, the longer the time in between thinking about it, realizing that you need to protect yourself, thinking about it, and actually deploying the force against another human being, the longer it is, the more it will appear to be criminal, not justifiable, and more like revenge. But when force comes down to survival, when is it criminal? And in the abstract, in the perfect world, never. Killing for survival is not criminal. But we have a couple of problems with that, because we all have this urge to revenge. And if we hesitate, if we let time elapse, it still may seem to us, in our clouded emotional judgment, to be self-defense when it is revenge. The time passing is not enough for our minds to take over our emotion, our intellect, our pen to take over our sword sometimes. And then, and that is for a pure of heart, decent person. What if you're not pure of heart? What if you are a sociopath, or you have sociopathic tendencies? What if you have bully tendencies? Can you lie and claim that you need to kill for survival when you're killing out of revenge, out of rage, out of this outsized sense of injustice? And you're a criminal, and you're doing this. Of course, that's part of the first course objective here, is this idea of how easy is it to abuse and lie about a self-defense claim, to mask offensive violence. And so as we transition in tomorrow's class and the next couple of classes into homicide, we talk about the degrees. First degree, the worst kind, the most serious kind of murder, involves significant time lapse. Enough time to allow cogitation, enough time to allow thinking, the thought process, the premeditation. And if it's a little bit shorter than that, but longer than self-defense, we have this idea of depraved mind that we're going to come to. Now, manslaughter is a second situation. First and second are temporal proximity issues. Much longer, not that much longer. Manslaughter is a separate matter. And then manslaughter and excusable are two things that are separate that we'll get to. But then, as we've been talking about in this video here, we'll summarize justifiable is the least time-passing use of violence. Now, if I were really good with this slide, the word manslaughter would have been grayed out up there, because those first degree, second degree, and justifiable are degrees of how much time passes between the thought to use violence and the actual violence. First degree murder, you stew on it all night. Go to your drawer, take your gun out, get a clip, load it, check your gun, go on the internet, find out where your victim works, get the map, get the address, find out if the person is working that night, drive there. That's a lot of time. That is an enormous amount of temporal proximity, and something akin to obvious that that's the worst kind of killing, to plan it out, to premeditate it. Second degree, much shorter, typically involving some kind of rage, some kind of frustration, violence, and longer in time than self-defense, justifiable. We'll get there. Let's talk about the bullet points, because part of what we're doing here is trying to define in a society when you can kill. So let's look at the bullet points in a little bit of detail here. The first two are on page 144. The third one's on page 145. I'm going to put them together here. Unlawfulness, necessity, and reasonableness. From our point of view, the reasonableness is the amount of force, whether you can shoot somebody or otherwise use deadly force to stop the attack, stop the kill or be killed situation, stop the use of force, the unlawful use of force against you. That's the third bullet point. And the first one is what I just said, the unlawfulness, that somebody else is using force against you and breaking the law in doing so. Number one, they're not a police officer with probable cause, because then that would be lawful. And you can't resort to self-defense under that circumstance. The other person may have mistakenly thought you were committing a crime. It makes for a complicated analysis of a jury. That did you still act in self-defense? But the most important of the three is the temporal proximity. Is it imminent, the harm about to take place? Immediate. Is it necessary to kill? Is it truly kill or be killed? So for the third bullet point, all you need to be reminded of is this idea: the amount of force must be reasonable under the circumstances, and that reasonableness is a question for the jury. So another way to describe the three bullet points is this definition of use of force. You've seen this before. The general principle is we will punish you. We will try to deter you. We will incapacitate you, maybe even rehabilitate you. You know, the four goals of the criminal justice system, should you resort to violence under every circumstance except defensive violence. Justifiable. So, again, back to the criminal and temporal proximity. We will not tolerate, we will not allow revenge in a modern, thriving society. But we will allow our members to protect themselves with deadly force, to kill instead of being killed. Now, up until the year 2005 in the state of Florida, before you could kill somebody in self-defense, you had to make every attempt to retreat. You had a duty, a legal duty to retreat, and if you did not, and you killed somebody in a kill or killed situation, you were still guilty of second-degree murder or maybe manslaughter, and you would still be liable to be sentenced to prison, even though you killed immediately to stop a deadly attack on yourself. 2005, the Florida legislature, and the first state in the country to do this, changed the law and did away with the duty to retreat. We call it stand your ground. Stand your ground was a dramatic, big change. Other states have now changed their laws. I think about 21, 22 states now have some form of no duty to retreat. Prior to that, the idea of duty to retreat goes back to English law when this country was still a colony. A long, long time ago, the idea was nobody should resort to use of force in a civilized society. And English people fancied themselves as civilized. They fancied themselves as holding up the pen over the sword. The pen was mightier than the sword, and civilized people don't kill. So if you ever were in the situation of kill or be killed, you should retreat and not kill. And of course, the exception to that was then, throughout the existence of this law in this country, you only had to try to retreat if it were possible, if you were cornered. If you were in this small little room, this 10 by 10 room, and the door is over here, and the force is coming through this door and it's immediate, you can't retreat. You could then kill to keep from being killed. But if, and let's make this my office, so let's change this to it's a public building office that I am in, not my home, because that's a separate matter. The castle doctrine comes into play. Let's talk about being out in public. I am now in my office, and I am at the door. And the door's over here, just to my left. And there's somebody else over in this corner threatening to kill me. And I can easily back out of the door, get away from this person. I could easily retreat. No longer am I required to do that. If that person over here in the corner is about to kill me, I don't have to retreat. I may stand my ground and meet force with force. So the main question I want to talk about in this review is this. To stand your ground make us more violent? The very basic theory, the widely accepted, long-standing principle of using deadly force in a civilized society was no, even if it was a kill or be killed situation, if you could retreat, if you could escape the danger without killing, you must by law. The state of Florida said nope, not anymore. Now, we're going to look at some statistics and some research and come up with some kind of broader understanding of the idea of stand your ground. Because stand your ground, no duty to retreat, is a change of the definition of justifiable use of deadly force. And the problem with changing the definition is if we make it too broad, then many more people can abuse self-defense claims as a pretext to mask offensive. And if we made it too narrow, then nobody could. So was the old English law that had been in effect in this state since it was a territory in 1821, it was a territory of the United States starting in 1821 with the English law of you must retreat as part of the Florida law. And then in 1845, when Florida became a state, we had the self-defense law required retreat from 1845 until 2005. No longer. And now you know what it says because you've read the jury instruction. But here it is. If you're in a place where you're not committing any crime yourself, you have a right to be there, you can stand your ground and meet force with force and have no duty to retreat, even if you could. That's the new definition. So let's do this. Let's talk about a few of the good parts and a few of the bad parts of the law. The law was drafted and promulgated and pushed onto the Florida legislature by a lobbying arm of the NRA. The NRA itself used to be an organization of social value. In the late 1800s, early 1900s, the National Rifle Association was a social organization to promote safe firearm possession and use, and to promote fathers handing down the tradition of self-defense, sport and firearm safety to their children, mostly to their sons. Because firearms are firearms are by far the most dangerous tool in any home that has firearms. By far, incredibly dangerous and not logical, not intuitive, not easy to use safely. But it doesn't mean they have no value. They have incredible value, first for self-protection in the hands of a proficient firearms owner, and secondly and thirdly, for the pure enjoyment of sport and collection. Firearms are fascinating, they're historic, they can be valuable, they can be works of art. They are fascinating collector's items to many people. And they're hours and hours of sporting enjoyment, target shooting and hunting. So firearms have, and they have a long standing history, not only a history in general in this country, from successful wars to self-protection, but a long history of family, generational possession and enjoyment, quality, safe enjoyment of firearms. And so the NRA supported that strongly up until the Civil Rights Movement, sometime in the mid-1960s, when African American men were in public, armed, and seeming to be a threat to the old way of white life. The NRA became politicized, especially in California with Governor Reagan. The Black Panther Party marched on the steps of the steps of the State House, not the White House, in Sacramento, California, with open carry, and it scared the hell out of the governor. And so the NRA stepped in, helped the governor, and since the 1960s, it not only became incredibly politicized, but incredibly lucrative. The executive board of the NRA got fabulously wealthy. And so they became this lobbying arm for arms manufacturers and ammo manufacturers. And they got the law changed in the state of Florida. Coincidentally, the new law may very well significantly encourage firearm and ammunition purchases. And it did. But what did the law do? The main important thing that this law did, the main improvement, the most difficult aspect of the Old English law of duty to retreat, was that if you honestly, truly, and clearly acted in self-defense, you don't have to go through the criminal justice system all the way through a jury trial. You get a mini trial in front of a judge called an immunity hearing. And if a judge decides at that trial, and it's early on in the process, if you kill somebody in self-defense and it appears from the evidence obvious, plain, a judge can decide that a prosecutor can't go forward at any criminal charges against you stemming from that killing. It saves money, time, heartache, worry, and the danger of a jury disagreeing and sending you to prison for various reasons that juries sometimes get things wrong. And even if the judge denies your immunity and says, yeah, it's a close call, or it doesn't appear clear that you acted in self-defense, you get a second bite at the apple. You get the jury to decide next. You get a lawyer to try to persuade the jury that you acted in self-defense. So you get 2 bites at the apple not to go to prison when it's a close call. And then you can't get sued. You can't get sued later for wrongful death by the family of the dead person. Another enormous benefit of this law. So in the year 2005, when the legislature changes law, the law sponsored by the NRA, 2 great things happen. And then yet another great thing happened. We clarified the definition of whether you had to retreat or not. In those cases where it wasn't perfectly clear whether you maybe should have had to retreat or not under the Old English law, there was no confusion any longer. You don't have to retreat. Good or bad, like that or not, it is at least perfectly clear to a jury. A jury can't get confused. It can't be unsure whether, oh, maybe you were close enough to that door or a window, or maybe if it were on a boat, maybe you should have jumped overboard instead of shot the person. No, none of that. Now, that second great aspect is certainly subject to your opinion on whether it's still a good idea to retreat or not, and maybe whether a jury should have been informed, but it is now clear. So, what do we got next? Some studies were done. Let me see what I got for my slides on the studies here. So here's our question. Again, no duty to retreat. Does it tend to escalate? Does it make us less civilized overall as a society? The Journal of the American Medical Association in somewhere around January 2017 did a study. They looked at all homicides since 2005 when the law changed. And they also looked at firearm homicides, and they looked at suicides by firearm. The theory is, in their study, if homicides and suicides both went up, then the law would have, the new law, Stand Your Ground, would not have impacted suicides, so therefore it wouldn't have impacted homicides. And what they found, though, was suicides remained the same. The number, the percentages in a population of people who committed suicide by firearm from 2005 until 2017 when the study was completed. Suicides by firearm remained on a percentage basis the same, but homicides by firearms increased significantly. And so they concluded, the doctors in that study concluded that it was a result of the change in the law. Now, this is a scientific statistical study, and it certainly isn't anything to do with inside the mind of a shooter, a killer, a justified killer or a criminal killer. Take it for whatever you may take this study for and compare it to the next study. The newspaper, the Tampa Bay Times, in August of 2013, went to every clerk's office in the state. 67 courthouses, maybe at least. I think there's 67 counties. I don't think there's a courthouse in every single county, but they went to every courthouse, pulled every court file where there was a trial since 2005 where somebody killed another person, got charged with murder, claimed that they were justified, that they were acting in self-defense, and that they had to stand their ground. And there was a total of 237 cases they looked at between 2005 and the study of August 2013. They were looking for 3 issues. How many times out of those 237 cases was an unarmed person killed? And the killer would claim self-defense. Partly under the theory that unarmed people may not need to be shot, that there may very well be a more rational, a more reasonable and less violent, more civilized way to handle that kind of confrontation than to kill an unarmed person. Maybe. They looked at the number of cases wherein the person claiming stand your ground actually chased the victim. Didn't stand there. They went and took steps toward the person they were about to kill. And finally, they looked at the times where the killer in self-defense could have retreated under the old law to avoid the conflict and didn't, and still stood their ground, because the law doesn't require retreat. Your mind can make up its own mind, so to speak. Stand your ground does not require that you stand your ground. It just allows that you can. And in that split-second decision, if you've thought through various scenarios of what you might do if you were confronted with a kill or be killed situation, and you thought, I would certainly look around to see if I could retreat before I killed anybody. Or maybe your mind, in a calm, rational, what would I do, what if situation, would say, oh, no. If I'm about to be killed, I'm going to shoot first. That's certainly your personal view, look at the world. So let's look at the number. Out of 237 cases, there were 148. That would be 62.5%, 2/3 of the 237 stand your ground cases involved the death of an unarmed victim. I can think easily of a time where it would be necessary to kill an unarmed person with a gun, to shoot with a gun and kill an unarmed person if they were choking me, if they were much larger than me and I was in a vulnerable position. They snuck up behind me, started to choke me. They're faster and stronger and had more endurance than I did, and they chased me down, or were about to chase me down, and they're making serious, violently loud, dangerous threats against my life. Certainly, I can see that. But out of 237 total cases in the entire state over an 8-year period from 2005 until 2013, do you think that all 148 of these cases in front of you right now all involved that kind of an incredibly dangerous unarmed victim? And if they didn't, anyone that didn't have that kind of dangerous victim, then what does that say about this definition, this new stand your ground definition? Doesn't it mean that every victim who was unarmed, who wasn't that kind of choke you, hands around your throat, choke you, chasing you, sneak up behind you kind of thing, was it not self-defense? Was it not justifiable then? Secondly, chasing it. I have a hard time trying to imagine the necessity. Remember the 3 bullet points: unlawfulness, necessity, and reasonableness of the amount of force. I have a very difficult time trying to figure out a scenario wherein you should be able to chase somebody in self-defense and kill them. Yet, I can come up with something fairly extreme. Let's say They had a shotgun. It was a pump shotgun. They turned it toward me. They were close enough to kill me, and they pumped around into it. It was live, ready to go. They were about to shoot. And they missed. And I know that shotgun holds 4 or 5 shotgun shells. They pump again, and it seems to jam. And I have a gun. They turn to run. They're still armed. I can't tell if that jam is a jam or if that shotgun is going to work. And I chase and kill them. Pretty extreme. Pretty unlikely scenario. Yet, self-defense. Justifiable? What do you think? Would that be 70 cases out of 237? 29.9, is that what that says? 29. Oh, I can't read without my glasses. 29.5 cases, 70 cases involved chasing somebody down. Remember, okay, before you remember, no, don't remember. Remember what we're talking about here. What is the question? Are we there yet? Are we there in your mind that the answer to this question is yes? Maybe not. Okay, so the number of times that a defendant could have retreated to avoid the conflict, 135, more than half the time. Now, prior to 2005, all 135 of those cases would have been criminal. If they could retreat but didn't and used deadly force, those people would probably go to prison. But there is one bulwark, one fence, one control to keep us from going to prison, even under those circumstances. In the law prior to 2005, is a jury could just say no, that the dead person needed to be killed. They were a very, very bad person. They were a bully. They were brutal. And although the killer was in that position of kill or be killed, and although they should have retreated, the law said it back in the day, they didn't retreat, we're going to forgive them and find them not guilty. That still could have happened in the year 2004 and prior. Now that's not an issue. There is no retreat. But before 2005, these 135 people would have been sent to prison because they could have retreated and didn't. Now, each of these 3 scenarios is different. But the middle one, chased the victim in 70 out of 237 cases. Does this law encourage violence, deadly violence? Does it encourage killing? And if it encourages killing, does it also effectuate that problem in defining self-defense? And that is the abuse of a self-defense claim as a pretext to mask offensive violence. So there's one more study we need to look at. Back in the day, in the 1950s and the 1960s especially, maybe a little bit into the 1970s, there was a company called Avon that manufactured and sold makeup. And it was a kind of a pyramid scheme, a multi-level marketing company wherein ordinary stay-at-home moms would buy big boxes, big bulk quantities of Avon makeup for a discount price, and they would go door to door in their neighborhoods and knock on their neighbors' doors to sell their makeup. And the company advertised heavily. And they always featured an attractive woman with a scarf and an old 1950s or 60s kind of beautiful getup, ringing a doorbell. So go ding dong, Avon calling. And so the seller on your doorstep was called the Avon lady. And the sarcastic among chiefs of police and prosecutors started to call this law in 2005, 2006, the kill your Avon lady law. In other words, people would get if people who were so frightened of somebody at their door ringing their bell, shoot through the door. Would that be stand your ground? Maybe. Nah, I won't even go there. But let's go right here. And let's take a look at the number of times before and after the law took effect that people went to trial, charged with first-degree murder, claimed self-defense, claimed justifiable use of deadly force, and were successful. In other words, successful being defined as a jury agreeing and finding them not guilty. Let's back up. Remember that the law takes effect. The law is voted into law in 2004, becomes law in 2005 in the state of Florida. But the cases involving claims of self-defense before the law was in effect go to trial in 2005 and 2006. So it wasn't until 2007 where the first cases got before a jury with a new definition of no duty to retreat. Stand your ground, meet force with force, including deadly force. If you're in a place where you have a right to be and you're not doing something unlawful. Look at the numbers. At the turn of the century, 32 people in the state of Florida who went to trial, killed somebody, went to trial and claimed self-defense, were found not guilty. The next year, 33. The next year, 35, then 32, 31. The numbers remain pretty consistent. 2005 it was 43. 2006, 33. We didn't have dramatic increases in either homicide rate nor the population of the state of Florida. Look at the numbers after the law. 2007, 102 people were found not guilty of first-degree murder or second-degree murder because they were justified. 93 in 2008, 105, 144, 98. Where are we? 119, 107, all the way up into the most recent year I have is 2015. Remaining constantly triple the number of people exonerated, found not guilty after the law changed. Does stand your ground increase violence? These statistics, I suggest to you, can't show that necessarily. Between the Tampa Bay study, the Journal of the American Medical Association view of homicide and suicide rates by firearm, and these numbers, I need to leave it up to you, and perhaps a writing that I'll have for you. I'll leave it up to you to decide. Perhaps one way to interpret the numbers on the screen right here is that the law clarified what the jury should do so well that in 2007, the people that were found not guilty should have been found not guilty before, but they weren't because the law wasn't clear enough to juries. And juries were sending some of these 60 or so people instead of, let's see, in 2007 it was 102 instead of 33. What was it, about 70 people should have been exonerated prior. Should have been found not guilty. But they're in prison now. Or is this truly in reverse? Was the duty to retreat law working well all these years from 1821 when Florida was a territory all the way up until 2005? Was the law working well and consistent in not punishing some people, but punishing those who appeared to abuse the law? When we loosen the definition of self-defense, of justifiable use of deadly force? Does it increase criminal activity that we can't punish, that juries don't understand? That's for you to decide. So let's wrap this video up. One more issue, and that issue is you can't protect private property. You can't protect your private property with deadly force. And what I mean by that is your private property that is not attached to your body. In other words, a chain around your neck, a wristwatch, a ring, a bag containing a briefcase with a laptop in it, a purse. That is not private property. That is part of your person, as the law decides and defines. And if someone tries to take that from you, you can use deadly force because that's a forcible felony. That's robbery. But if I have a boat, I'm now at home. If I have a boat out in my driveway on a trailer with a nice chain on it, decently tied down with a good, solid, safe chain, and the tow hitch is facing out the street because it's a lot easier to tow that way, and tonight, in the middle of the night, somebody comes by with a giant pair of bolt cutters, cuts my chain, hooks up my boat. The law will not allow me to kill them, to keep them from stealing my boat. And if that's the only way to stop them, then I have to lose my boat to them. And if you're sitting there saying, oh, no, I am not letting that happen, I understand the impulse. Many people would still have that impulse, but if you act on that impulse, you commit a crime in the state of Florida. You commit a crime anywhere in this country. You can't use deadly force to keep somebody from stealing your property, your car, your boat, whatever, your dog in the backyard, your beautiful, beautiful family dog. And let's say it's a very valuable one even. It's not a mutt that you rescued that may not have financial value. Let's say it's a $15,000 breeding, rare, spectacular dog. You can't use deadly force. You can use reasonable force. You can't shoot into the dirt. That's deadly force. You can't shoot up in the air. You can't do it. And part of the theory is that we have insurance, we have 911, we have police response. And in the old days, we didn't. Bottom line is you can't kill to protect your property. But let's go back to that same idea that a jury still may find you not guilty. They may say that guy deserved to die. He was stealing the guy's boat. What did you want him to do? He was stealing his boat. But it's not the law. A jury can sometimes disregard the law. It's called jury nullification. And a jury can do that. But if you're going to count on it, if you think that you may avoid going to prison because you killed somebody to protect your boat or other valuable property, the odds become pretty low. The plea offer will certainly even involve 5, 10, 15 years of prison. And we have all kinds of ways to protect our property that are now illegal, and some of them are kind of obvious. The tripwire kind of thing. And if somebody's done this before, if you're away, if you own a vacation home, if you own a little cabin on Lake Okeechobee, out in the woods, down a dirt road, and you hardly ever get to go there, and it was your grandfather's, and it's all you have left to your grandfather, and the kids out in Okeechobee go out there and they smoke weed, and they have sex out in your cabin, and they urinate and defecate, and then they just destroy your property. And you set up a tripwire like this. And you put signs all around. This property is defended by deadly force. Come onto this property at your own risk. We don't allow it. We just don't allow it in a civilized society. And one of the most obvious reasons we don't allow it is when you don't have a human being making the wise and legal determination of using that deadly force, when it's just a machine that gets tripped, first responders, innocent people, maybe somebody from your family. Oh, did you remember to disarm the tripwire? Oh, no. And your mom just got shot when all three of you are walking out to the cabin. I mean, we have thought of brutal, brutal ways to protect property and to kill people without actively pointing a gun at them. This is a Vietnamese killing hole wherein these spikes have barbs on them, and they were covered with, not only the spikes were covered with feces, but the hole was covered with palm fronds, so you could be running toward the protected bunker, the protected area, and fall into the hole. Go down into it, and then as your fellow soldiers pull you out, the meat on your legs gets stripped off like boiled chicken. We got the tripwire spike ball. We've got the bank exploding money that is also illegal for personal use. Banks can use this. Bottom line is you can't defend property with deadly force. So take a look at the statistics. Take a look. I'll post these slides. Take a look at the slides. Take a look at the statistics. You come to your own decision on whether stand your ground overall is a good law. All right. I'll see you tomorrow night. Let me tell you, when you watch this video, I probably should have said this at the beginning instead of the end, but I'm going to say it now at the end because I forgot. Put the speed on 1.5. I think I'm going to post this right on top of where I post the video on Canvas. Put this speed on 1.5. Make me speed up. You don't need to sit here for 35 or 40 minutes, however long this video is. Speed it up. Whip through this. Cover the self-defense, deadly force review that I just did. And you got this. I'll see you tomorrow.